Good morning. To the members of the House, we are here to undertake an examination of Resolution 111. This resolution is proposed to remove the legal barriers to marriage equality. You see, the denial of civil marriage to same-sex couples harms them and their families, excluding them from critical legal protections that married persons take for granted in the areas of family law, trust and estates, property law, tax, employment, health, and parental and custody matters. Let us be clear that this is a legal issue. It is also important to recognize that our colleagues of same-sex relationships deserve the same protection that we all have enjoyed under the founding documents of this country. This is about equality. And when it was stated that all men were created equal, we had to examine that from time to time with regard to other members of our society and concluded that women were equal, that members of different races were equal, and that those who had disabilities were equal. Today, we should say that those of the same sex are equal in all respects regarding all the laws of this country. You see, the legal recognition is an expression of the reality of the social landscape of our society. Same-sex relationships are clear, they exist, and they are here to stay. They involve relationships among our friends, among our neighbors, and among the members of our house. Let me close with this. We can choose to stand on the sidelines, or we can be on the field. There were times when this association was on the sidelines. Today, we should be on the field. Thank you.
Chair recognizes, thank you, Mr. Gray. Thank you, Mr. Gray. The chair recognizes Carolyn Lamb, President of the Association, to speak in favor of the recommendation.
In 2004, the House of Delegates overwhelmingly approved a resolution opposing efforts to enact a federal constitutional amendment or other law that would prohibit states from permitting marriages between two persons of the same sex. In 2009, the House approved a resolution urging the repeal of Section 3 of the Federal Defense of Marriage Act, which denies over 1,000 federal marital benefits and protections to same-sex spouses who are lawfully married under state law. I am proud that the House saw fit to adopt these policies. Now it is time for us to take the next step. Our current policies acknowledge that marriage has always been a state matter under our federal system and should remain so. Far from being inconsistent with that principle, the present resolution reaffirms it, seeking not to overstate or override state responsibility, but rather to persuade states as a matter of policy to exercise their authority in a manner that accords equal treatment to same-sex couples and their families. Each jurisdiction that I call home, the states have already taken that step. In D.C., Vermont, and Massachusetts, none of them has weakened my marriage, my family, or the institution of marriage. The only effect is that those in same-sex relationships have equal rights. It's time for this association to join the call for marriage equality. In so doing, we will honor the dignity and value of loving and committed relationships while affirming the principle of civil equality that stands at the core of our profession and ideals. I urge your support.
The chair recognizes Les Jacobs of the Ohio State Bar Association to speak in opposition.
Thank you, Mr. Chair. I have reluctantly concluded that silence on an issue of political correctness is cowardice, and that we owe it to this House to avoid action that would jeopardize the welfare of the association. So I rise to urge restraint. Not that you pocket your views or cease to advocate them anywhere and everywhere that you find an opportunity to do so. But I personally believe it can be suicidal for the House to defer to an impulse to impose social and political and cultural values on the entire membership of the ABA, rather than to endeavor to reflect some clear consensus of the bar. When an attitudinal value is not broadly shared, and when people of goodwill have sharply divergent views that are both fundamental and, frankly, irreconcilable, it is axiomatic, I believe, that lawyers will be found not only to disagree with each other, but to be engaged as advocates on both sides of the proposition, on the merits, whether in litigation or in legislation. An organization that purports to speak for lawyers in the aggregate should be careful, I suggest, to do so only where the prevailing sentiment of the members of the bar can be determined with some validity. Some of you, and some in the well, are directed by the organization you represent on this report. That's fine. But I seriously doubt that most of you are prepared to vote on the basis of what America's lawyers chose you to do in the House, expects you to do in the House, and want you to do in the House. Do you truly know the desires of your constituents on such a broad scope proposition? Or are you intending to indulge your personal preference on one side or the other? This is not Congress, nor is it a political convention, although it sometimes resembles one. But what we do seriously affects our perception in lawmaking fora. And if we're perceived to be off base on something that lawmakers readily understand, I suggest that we cannot expect them to defer to us on something they don't understand. Please confine yourself to those issues on which lawyers have clearly superior knowledge and where they have something approaching a consensus. I do not believe this is such a proposition.
Chair recognizes Thomas Wells, Jr., immediate past president, to speak in favor of Resolution 111.
Thank you, Mr. Chair. Ladies and gentlemen, eliminating legal barriers to civil marriage between persons of the same sex who are otherwise eligible to marry does not redefine marriage. It doesn't redefine marriage any more than Mildred and Richard Loving were redefining marriage. It doesn't create a, quote, new right to same-sex marriage any more than Loving versus Virginia created a new right to interracial marriage. Our citizens of the same sex who are being denied the right to a civil marriage are only seeking to participate on an equal basis in a foundational institution of our social and economic life. They're not trying to change marriage. They simply want to share in the legal blessings that we give to married couples. I submit that this could only strengthen marriage. It certainly does not threaten it. It also does not threaten in any way religious liberty. If all the barriers to civil marriage were lifted tomorrow, religious organizations would continue to decide which marriage they would perform and which they would not. We are not talking about solemnizing religious marriages. We are talking about a civil right. The resolution seeks only to extend to persons of the same sex the same civil status that is currently accorded to opposite-sex couples. This is a matter of simple civil justice, nothing more and nothing less. Thank you.
The chair recognizes Stephen Zack, President-elect of the Association, to speak in favor of the resolution.
Thank you, Mr. Chair.
Mr. Zack.
As a former chair of this House, I do not believe in repeating what other people say. So I am only going to ask you one question, and that is, why would anyone in this country not want two people who love each other not to enjoy the blessings of marriage and the full protection of law? Would any one of us want our marriages that we hold so sacred to be called civil unions? And aren't all Americans entitled to the same right? Our fundamental purpose for being is to reject and deny discrimination anywhere at any time. Please vote in favor of this resolution.